Hola a todos y bienvenidos de nuevo a Aprendiendo con Lex Nova Jr. Abogados. Hoy profundizaremos en un concepto legal fascinante: la capacidad. Now, we use the word capacity all the time in everyday conversation. We might talk about having the capacity to lift a heavy object, meaning strength, or the capacity to achieve a goal, meaning aptitude. The dictionary even defines it as the talent or quality for doing something well. We also use it for measurement, like the capacity of a bottle is 1 liter. This last idea, capacity as a measurement, is actually pretty close to how the law thinks about it. In previous videos, we defined a person as any entity capable of having legal rights and duties. But this raises a question. Does every person have an unlimited ability to hold every single right and duty that exists in the law? The answer is a clear no. Think about it this way. All human beings are considered persons and are therefore capable of having rights and duties. In that basic sense, we're all equal. However, the extent of those rights and duties can differ. For example, all children generally have the right to inherit from their parents. But what if one child is declared unworthy by a court, maybe because of a serious offense against the parent? That child loses the right to that specific inheritance. See what happened there? The unworthy child is still a person, just as much as their siblings. Their personhood isn't diminished, but their aptitude to hold certain rights has been reduced. This is where the legal term capacity comes in. It's the system we use to measure that aptitude. So, a great way to define legal capacity is the measure of a person's aptitude for legal rights and duties. Some legal scholars define capacity simply as the aptitude itself, essentially equating it with what we call legal personality. Legal personality is the quality that all persons have, just by being persons, which allows them to have rights and duties in the first place, something a rock or an animal doesn't have. For instance, a 5-year-old has the right to inherit from their parents. A teenager or a mentally incapacitated person has the legal possibility of owning a house they might buy or sell. But here is the crucial question: can that 5-year-old or that teenager go out and personally complete the sale of a house? Obviously not. And this is where the second major type of capacity comes into play: the capacity to act. This is the measure of the aptitude to produce full legal effects through one's own voluntary acts. So, while our 5-year-old has the capacity of enjoyment, the right to own property, they lack the capacity to act. The law wouldn't recognize a contract they signed as having full legal effect. The ability to act for oneself is acquired based on different factors depending on the situation. Let's break down the capacity to act into a few subtypes. The first is negotiable capacity, or the capacity of exercise. This is the measure of the aptitude to validly enter into legal transactions in one's own name. For this, the law typically looks at an objective factor, age. But in many legal systems, like Venezuela's civil code, a person is considered fully capable for all acts of civil life upon turning 18. An 18-year-old can sign a sales contract on their own, without needing a representative, and that contract will be legally binding. They have full negotiable capacity, something they didn't have as a child or teenager. Next, let's consider a different scenario. What if someone's actions aren't about business deals, but about causing harm? This involves what's known as delictual capacity, or capacity for imputation. This is the measure of the aptitude to be held liable for one's own wrongful acts. Imagine a teenager playing baseball in the street and accidentally breaking a neighbor's car windshield. This act causes damage and, in principle, creates an obligation to repair it. But is the teenager themselves responsible? Here, the law doesn't just look at age. It considers a subjective element: discernment. This means the victim might be able to sue both the teenagers they had discernment and the parents. When a person wants to assert their rights before a judge, the law requires them to have the necessary aptitude for their actions within the legal process to be valid. In other words, it's the ability to act in a trial, either as a party or as a third party. For example, a minor can be the legitimate owner of a property right, but they lack the procedural capacity to appear in court by themselves to defend it. They must be represented by their parent or guardian. Like negotiable capacity, full procedural capacity is generally acquired at the age of 18. However, modern law, especially in the area of child and adolescent rights, has introduced the idea of progressive capacity. This means that as a young person matures, they gradually gain more capacity. For example, laws protecting children and adolescents might grant teenagers limited procedural capacity. They might be able to go to court on their own to defend certain rights that the law already allows them to exercise personally. A great example is in labor law. If a teenager is legally allowed to sign their own employment contract, it makes sense that they should also have the procedural capacity to go to the court by themselves to enforce their rights under that contract, including hiring their own lawyer. Even in these cases, the law recognizes the ongoing role of parents. They can typically join the lawsuit as interested third parties to help protect their child's interests. But this progressive capacity has its limits. Even if a teenager can sue for their wages, they probably can't make a major legal decision within that lawsuit, like settling the case, which involves giving up rights. Such an act of disposition would still require the involvement of their parents and approval from a judge. So, to wrap it all up, every human being has the capacity of enjoyment, the potential to hold rights and duties. But not everyone has the capacity to act, the ability to exercise those rights on their own. And even those who have the capacity to act might have it in a limited way. A teenager might have procedural capacity for a labor dispute, but still lack the full negotiable capacity to sell a house. Full capacity to act across all areas is typically something that comes with reaching the age of majority, usually 18. Understanding these distinctions is fundamental to navigating the legal world. It shows how the law carefully balances protecting individuals with empowering them to act for themselves. Thanks for joining us for this deep dive into legal capacity. If you found this helpful, please give us a thumbs up, subscribe to Lex Nova Junior Attorneys, and hit that notification bell so you don't miss our next video. See you next time.